thanks everybody for joining us today. So we're starting off the year right, and we're going to be talking about making a fresh start if you haven't done an estate plan yet and you've been thinking about it. And if you have done an estate plan, then let's take a fresh look at it. So Kathleen is going to be talking a little bit more about what you need to be looking for and how to go about doing that. So without further ado, I will have Kathleen take over.
Well, hello, everyone. Thank you so much for joining us. I cannot believe we're talking about the end of January already of 2024, but here we are. And one of the things that we talk a lot about in the office is using this time of year to really kind of set goals and as Carol said, either a fresh start on things if you have never done estate planning before, or to use this time to really be able to look at your current estate plan and see if there's any reason to be considering updates. And so I want to go through that with you. Some of this is going to be very basic things, again, that many of you may know if you've already done your estate plan. But if you're new to it, it's going to give you a little background about estate planning itself. And setting goals for ourselves. I don't know how many of you are still following your New Year's resolutions. Hopefully you are, but this is, again, a good time to kind of recommit to those New Year's resolutions, including looking at your estate plan. So I want to just review a little bit about what estate planning is. And again, whether you're new to estate planning or whether you've done estate planning before, remember, it's not just about what happens after you've passed away, although that's certainly a big portion of an estate plan. But it can include many different things. It includes things like tax planning. And I'll talk a little bit about a change that happened last year for estate taxes here in Massachusetts and how that may or may not affect your estate plan. Looking at issues regarding family harmony. We don't want our estate plans, or many of us after we have died, we certainly don't want the decisions that we have made, if we can help it, to in any way affect or destroy our family harmony. And this is a good time to be able to take a look at issues that may come up, both while you're still alive and certainly after your death. Legacy planning. Now, this is the basic part of estate planning, which talks about what's going to happen after you've died. But it includes more than just who's going to get your assets sometimes. We can oftentimes include other things with respect to legacy planning, things that are important to you, supporting charitable organizations that may be important to you, that kind of thing, and part of the whole legacy portion of things. And then talking about asset protection. For some of us, that's an important issue, whether it be that you are worried about something like long-term care costs or in relationship to tax planning, but looking for ways to be able to protect assets when appropriate. So oftentimes people will say, what is part of my estate? What really goes into an estate? And it includes many different things. It's basically your assets. That would include money assets that you might have, savings, investment, retirement plans, those kinds of things. It includes real estate that you have, possibly business that you own, life insurance policies, and it also includes things like your stuff, your personal property, maybe collections that you have, art collection, maybe you have a collection of cars, baseball cards, that kind of thing. And don't forget our pets. Pets are really important. So if you're someone who already has an estate plan in place, some of the things that you might want to think about with respect to whether changes need to be made this year is I would ask you to take a look at what happened during 2023. Did you possibly sell a home or buy a home, maybe a vacation home? Did you lose a loved one, or maybe add loved ones to your family network? Maybe there was a marriage in your family or the birth of a child. Did you retire, or are you getting ready for retirement? These are other reasons to potentially take a look at your estate plan and make sure that it's still reflecting your goals. Did you buy a pet? So many people, particularly during COVID, bought a pet, and planning for that pet certainly can be part of an estate plan, particularly based on the type of pet it may be. I have clients who own horses per se, let's say, and a horse can live many, many years, decades. And so providing for them past our lifetime may be something that's important to take a look at. So when considering, do you have to or want to make changes to your estate plan? I always recommend you take a look at what happened during the past year and see whether there have been changes in your family situation, your financial situation, your goals that we want to make sure are reflected in your estate plan currently. So there are two kinds of parts of estate planning. First is, a lot of us know about the financial part. I mean, certainly talking about what to do with our assets, our savings, our investments, our real estate, how to handle life insurance policies, retirement plans. All of that really is kind of a no-brainer in some ways when we're talking about estate plans and what it involves. But it involves, again, more than just that. Talking about the important people in your life and how either you want to take care of them or who you want to identify to be in your shoes should some reason you lose your competency, capacity to be able to make decisions for yourself. Identifying the important people in your life, both from a legacy standpoint as well as a care standpoint for yourself and a decision-making standpoint, is important. Thinking about what your legacy would look like. Do you want to provide for grandchildren, let's say? Is education important to you and you want to make sure something is funded for a loved one as they grow, to make sure that they're able to take advantage of educational opportunities? Are you worried about your spouse, worried about yourself in terms of how you're going to afford care in the future, let's say long-term care, or to be able to fund the things that you want to do, to be able to go on vacation, let's say? Maybe you do want to buy a second home and you want to be able to look at ways either to protect that home or ensure that when you pass that home on, you're able to keep family harmony in mind. So looking at your aging goals, what's important to you? What are the things that you want to do? Maybe you're looking at this point to make a change, sell your primary home and move to a new community, looking at things like retirement communities or another area of the state to be able to live in, to be able to enjoy a different lifestyle. So looking at your retirement goals, if you're getting ready to retire or recently retired, again, what is important to you and what do you want to be able to make sure happens and that your estate plan supports those goals. So first of all, taking a look at a fresh start. If you've never done estate planning before, there's a lot of different things that we need to look at. And even if you have done estate planning, sometimes people will get the legal documents in place, but they forget about some of the other things. So for instance, how do you hold your assets? Do you jointly own them with someone else? Because remember, those assets that are jointly titled or held with someone else, let's say you have a bank account in which you own with your spouse or you own with another loved one, that will go to that joint owner regardless of what you've written in your will or in your trust. So it's important to understand how you own your assets, how they're titled, because that's going to affect how that title passes after your death. Are you concerned about delays in the cost of estate, let's say probate? When we have a will as the basis of our estate plan, remember that wills always require probate. So if there are assets that you own individually when you die, then those assets must go through probate in order to be able to pass on to whoever it is that you have identified as being able to take them. And if you're looking to avoid probate, then we need to look at a different way for planning to occur. And that again can be through the titling of assets, jointly held assets, let's say, or naming people as beneficiaries of assets, or we can create a trust, which I'll talk about a little bit later. But there are many ways to be able to deal with the concern of avoiding probate. Do you have people who are dependent on you? Again, we want to make sure that certainly upon your death that the people who are dependent upon you are taken care of. But we also want to make sure that if you become incompetent or incapacitated for any reason, that those people are provided for. If you have beneficiaries who are under the age of 21, or let's say someone who is not good at being able to manage money, we can plan ahead for those people to make sure their assets might be held in some kind of ongoing trust situation. One of the things that I oftentimes will get a question about is there might be a child, let's say an adult child, who is going through a tough time, whether it be that they have financial insecurity, whether it be that they might be looking at a divorce, that type of situation. Then looking at your estate plan, this is a good time to do that, to make sure that you have things properly kind of buttoned up, that they're taken care of in a way that you want them to be taken care of, to ensure that they will flow the way you want them to flow upon your death, and not maybe get caught up in some kind of a divorce settlement. Or if a child, let's say, is not managing their finances well and you're worried about their abilities, that they don't go to the child directly and somehow that they are put into a format that will hold those assets for the benefit of that child or that loved one without going to them directly. If this isn't your first marriage, if you have you've been married before, you have children, let's say, both from a previous family as well as, let's say, your new family, or you're mixing family members together, that's also a good time to take a look at your estate plan and again, make sure that you're providing for people the way you want to. Remember that a spouse, if you're getting married again, always has a right to a share of your estate. And so having a properly written estate plan will make sure that if you want to provide for that new spouse, you do so. But if you want to ensure that people, let's say children from your first marriage, are properly provided for, or the way you want to provide for them is properly written in your documents. Are you concerned about family disputes? Oftentimes that will happen. You might decide that you are not providing equally, let's say, among your loved ones, which again is your right to do, but you want to make sure it's done in such a way that there's clarity and that there's no ability for someone to be able to argue successfully that they should have gotten more of your estate. We see this a lot with second homes. So if someone has purchased a second home, we want to oftentimes take a look at how that second home is going to pass on. I always hear clients say things like, I have a home, let's say on the Cape, and we love that home. It's our family's place to be able to gather. Well, that's really true while you own the home and while you control who gets to use it and usually are paying all the bills associated with it. But when it passes on to the next generation, it can cause a lot of friction between family members. Who's going to decide who gets to use it and when? Who's going to handle the cost associated with it, etc. So those things should really be looked at as part of the plan. And certainly if you have someone who's disabled, if you have a loved one who's disabled in any way, whether it be a spouse who has, a diagnosis of some type of an illness, or you have a loved one who may have either a diagnosis of an illness or a lifetime disability, we want to make sure that we're properly planning for those individuals so that we're not disrupting any kind of benefits that they may be receiving from, let's say, the federal or state government. So taking a look at all of those things are really important, whether you're starting your estate plan for the first time, or again, if things have changed over the past year for you. So a couple of things we always say to people in terms of a little bit of a checklist, has it been a couple of years since you've reviewed your estate plan? Now, whether you sit down with an attorney, with our office or someone else to do that is up to you, but you really should take out your documents, take a look at them. What does your will say? What does your trust say? And does it still reflect your wishes? And are the people that you've named, particularly in some of the important positions, let's say of personal representative or trustee to manage your trust, or someone who you've asked to be your personal representative or your healthcare proxy, are these still people that you want in those important positions? Does that plan still reflect your goals? Again, things change over time. You may have thought that you were going this direction and you've decided to go that direction. And does that estate plan reflect your wishes as you've made changes, as you've aged, and things may, your wishes and goals may change over time? Have there been those major life changes for you? Again, births, deaths, divorces, marriages, all of these types of things can really affect your estate plan and what you may have as goals as you go forward. Getting ready for retirement, that can be a huge change for many of us. And it really does both give us time to be able to do more and have an ability, hopefully, to be able to enjoy the things that we would like to do more, but it requires planning, both on a financial end, which we don't do, but if you don't have someone you work with, we're happy to make that referral for you. But the financial end of things and the estate planning portion of things, want to make sure that those both mesh together to make sure your goals are met. Taking a look, this is a great time of year to pull out as you're getting those 1099s in, you're getting your tax forms in, taking a look at your retirement plans. Who do you have named in those documents as your beneficiaries? Remember, oftentimes I find that a client will come to see me and they had been married, and let's say they lost their spouse, even as long as ago as 5-10 years ago. But when they pull out their retirement plan, they find they never changed the beneficiary of that plan, whether it's a retirement plan, if you have life insurance policies. This is a good time to take a look at anything that you have named beneficiaries on and make sure that you have properly named the primary beneficiaries to be the people that you want. And if possible, that you've put contingent beneficiaries on and that you update those as needed. Really critical when there's been a change in a marital status, whether it be your marital status or that of a child or another loved one who you're providing for, that you update those beneficial designations to make sure it's reflecting your wishes. And with respect to things like healthcare decision-making and your powers of attorney, have you named the people that you want should you become incompetent or incapacitated for any reason, who you would like to have step into your shoes to make decisions for you? Oftentimes, I joke a little bit, the people who we named back when our children were young in our estate plan to be guardians for them, should something have happened to my husband and I before they hit the age of 18, changed dramatically when our children got into their early teen years. Very different needs of our children at that point. And the people we had originally named were not the people we felt would be the best ones to now deal with them and to help them should we both pass away, my husband and I. So taking a look at your estate plan, making sure that it's reflecting your wishes still, that the people who you've named in those important fiduciary positions are still the ones that you want to serve, and that any changes in your life are being reflected in the way you want them to in your estate planning documents.
Kathleen,
Yes.
should a CD of $100,000 be in a trust?
So it depends. Usually, if you have a revocable trust, then putting it in the trust, the benefit of you doing so is that the trust will own it. Typically, you're the trustee, so you're managing it, and typically you're the beneficiary if it's a revocable trust. And it allows it so it makes it so that if you lose your competency or capacity, or upon your death, it's already part of the trust and does not become subject to a probate proceeding. If you don't put it into the trust and you were to die during the life of that CD, then it's going to be a probate asset that has to get dealt with by your estate plan, unless somehow your financial institution allows you to name a beneficiary. So yes, if you can move that in, but I always tell people don't cash out that CD if it's going to cause you penalties and loss of interest. Wait until it comes to its next maturity date and then get it into your trust. So let's go back and review just kind of the basic components of an estate plan. And those of you who have heard me speak about this before probably can do this with me, but it's really important again to remember what these documents are for. And again, to take a look at who you've named to be the fiduciary, the person who will be stepping into your shoes or managing things for you, should you be unable to or upon your death. So the first one is that durable power of attorney. Remember, this is the very broad document that gives a tremendous amount of authority to the person of your choosing to step into your shoes to manage all decision-making but healthcare. So this is where you're naming somebody that if you become incompetent or incapacitated, they can manage your financial affairs, handle your life insurance, handle your retirement, take care of your tax filings, making all of the kinds of financial decisions that may need to be made should you not be able to do so for yourself. Remember, there are two types of powers of attorney. There's one that becomes effective on the day you sign it. So even though you're completely competent and capable of managing things, you can ask your power of attorney to be able to, or your attorney in fact, that's what we call the person, to step into your shoes, let's say, and handle that aspect of things for you. The other type of power of attorney is called a springing power of attorney. And it requires that first you be declared incompetent or incapacitated by a healthcare provider before it becomes effective. So it has a little bit of a check and balance in it. Nobody's running around doing anything on your behalf unless there's a reason, such as incompetence or incapacity. But it does put that hurdle. They have to go about getting that documentation, which can be a little bit of a pain to be able to get in place. But a power of attorney is critical. If you don't have one in place, then what happens is if you lose your competency or capacity, we have to go to court and get a conservator appointed. So this allows you to be able to appoint the person of your choosing. So I encourage you, if you've done your powers of attorney before, pull out that document. Make sure that the person you asked to be in that position is the person that you want. And you oftentimes will have successor people named so that if the first person can't serve or is unwilling to for any reason, you have another person named already. Double check those names and make sure they're still the people that you want in this position. A couple of other things about powers of attorney to know, they oftentimes include things like the ability to make gifts on your behalf and the ability to do what we call self-deal. And that means that the person who's acting as the attorney, in fact, they are able to actually benefit from the decisions that they make. Now, if someone like myself was working as your power of attorney, you might not want me to have that ability to be able to benefit from what I'm doing, to be able to self-deal. But if it is your child or your spouse or some other loved one who you may be providing for in some way, then you want them to be able to, in most circumstances, self-deal so that they're able to benefit from your estate just like everyone else. Healthcare decisions, remember this is the healthcare proxy. And again, this is a document in which you've given authority to someone else to step into your shoes to make healthcare decisions, but only in the event that you become incompetent or incapacitated. Take a look at that document and again, make sure the person that you've asked to be your healthcare proxy is the individual or that you would like to be in that position still and that they're willing to do so. And that anyone you've named as a successor is still the person or people that you want in those positions. It's critical to have conversations with the people that you've asked to be in these important positions, both your power of attorney and your healthcare proxy, but particularly the healthcare proxy, because the document doesn't actually tell us anything. All it does is give authority to the person that you've asked to be in that position of a healthcare proxy. So this is a good time to think about sitting down with whoever you've asked to be your proxy and talking with them about what your wishes are should you not be able to make healthcare decisions for yourself. And remember, oftentimes they're stepping into your shoes when we're talking about end of life decisions. So having that conversation with them is really critical, giving them a framework in order to be able to make decisions about your healthcare. And from the power of attorney, to have people at least know where to begin. You don't have to show them your finances now. You don't have to share any of that information, but make sure the people you've asked to be in these important positions know where to find that information, or at least begin if something were to happen to you. Sometimes that's just making sure that if we've done your documents for you, that they have our name and number, so that if something were to happen to you, they can call us and begin to do what they need to do to act on your behalf appropriately. Think about that as a to-do as well. Talk with the people you've asked to be in these important positions so that they know what your wishes are, particularly around healthcare decisions. A living will document is oftentimes something that we also add to an estate plan. Now, remember, a living will document actually is not legally binding here in Massachusetts, but it does give some framework about what your thinking is, what your wishes are around particularly end of life decisions. It talks about wanting your healthcare needs met, wanting to be taken care of. Typically, though, it states that you don't want to have extraordinary measures. Now, one of the things that can be put in place, not with us as your attorneys, but with your healthcare provider, is a MOLST form. A MOLST form stands for Medical Orders for Life-Sustaining Treatment, and this is done with your doctor or nurse practitioner to talk about things like do not resuscitate, a DNR, do not rehospitalize, no feeding tubes. All of those kinds of things that are specific to your wishes can be put in place in a MOLST form. Think about it as like a prescription for healthcare decision making, because once it's signed, it can be honored regardless of what type of medical setting or at home, if you're at home and getting care, that you might be in. So it's a medical order from a doctor or from a nurse practitioner that can be followed whether you're at home, in a hospital, in a long-term care setting, etc. Now, not all physicians will put a MOLST form in place for all people. There's a couple of things that oftentimes have to be happening. Number one, oftentimes they'll only do it with people who are really at kind of end stage, which means either there's been some kind of acute situation that has occurred that they believe will end up in the person dying, or a long-term situation, kind of a chronic illness that, again, the belief is that this will lead to the death of the individual. Some physicians will also do it for people of a certain age. And I kind of use the quote marks because that's a very subjective thing. What is old enough to put in place something like a do not resuscitate or a do not hospitalize? So if it's something you're interested in, you definitely want to have that conversation with your physician and see whether he or she is willing to work with you and put in place a MOLST form. Another healthcare document that you should be looking at is the HIPAA authorization and release form. HIPAA stands for Health Insurance Portability and Accountability Act. It was put in place in the early 2000s. And this, again, is a document in which you're naming people who you want your healthcare providers to share information with. Now, these people may or may not be decision makers, but remember, the decision makers are identified on your healthcare proxy. This may be a larger group of people. So, for instance, I have 3 children. I've named one of them as the primary decision maker for me on my healthcare proxy. But I want to make sure that my other 2 children are also able to speak with my healthcare providers. So this gives you the opportunity to name additional people to be part of a conversation. A couple of other things that I want to talk about in terms of estate planning really surround what happens after you've passed away. And that's where the last will and testament comes into play. Remember, it's only effective upon your death, and it's going to talk about how you want your assets, your holdings, to be distributed after your death. I like to think of it as an instruction sheet to tell us what to do with the assets that you own individually upon your death. It's also going to tell us who's going to manage your estate, your personal representative. So again, if you have a last will and testament in place, this is a good time to pull it out. Make sure that the instructions that are in this document are reflecting your wishes, and that the person or people that you have named to be the personal representative to manage your estate after you've died are actually the people you still want in that position, and that they're willing to do so. Now, one thing to remember always about a last will and testament is that it will always require probate. And probate is a court proceeding that when someone has died and they own assets in just their own name, and this is going back to that question about should a CD go into a trust. If that CD is not in a trust and it is still owned by the individual and has no named beneficiary, that CD will be subject to probate. So we need to go to the court. The court will accept the last will and testament if there is one, and they'll validate that it is the last will and testament, and they'll give permission to the person that you've named to be the personal representative to act on behalf of the estate. Now, probate gets a little bit of a bad rap, but it is a court proceeding, so it does involve the courts, it involves time, and it involves money. And so there's cost associated with having to go through a probate proceeding, including filing fees and costs that have to be paid to the courts. So a will always should be in place, regardless of your situation, but there's a way of our avoiding probate. There's actually multiple ways of our avoiding probate. So I want to talk about that a little bit in terms of trusts and the things that you should think about, whether you have a trust in place right now or whether it's something that you would like to put in place. So there are a million types of trusts out there, as I always say, but there are two main categories of trusts: revocable or revocable trusts and irrevocable or irrevocable trusts. So let me talk about the revocable trust first. This is one that you put together during your life, that you are the trustee, so you're managing the trust during your lifetime, and you are the beneficiary of that trust during your lifetime. This is where you would take something like that CD and you would put it into the trust because you still get to control it. You can spend that CD in any way you want. You make all the decisions about how investments are handled, and you can take assets and put them in the trust and take them out of the trust without having to ask anybody's permission. You are only responsible to yourself if it's an individual trust. And if it's a joint trust with a spouse, then it's just the two spouses that are responsible for it and responsible to each other in terms of what they're doing. It's a great way to avoid probate. Probate, again, is that process we have to go through when you own assets yourself when you die. When you have a revocable trust, as long as you have funded that trust and actually put the assets into the trust during your lifetime, then upon death, those assets are not owned by you, they're owned by your trust. And the trust becomes the instruction sheet. It tells us how to pass on those assets after your death. And we don't have to involve a court in any way. So this is another great time of year to be taking a look. If you do have a trust, have you funded it? Have you actually moved assets into the trust? Is your real estate owned by the trust? Are your savings and investment accounts, checking account owned by the trust? Non-retirement assets, because remember, retirement assets always have to be owned by you individually, but they should have named beneficiaries. But other assets should actually be in the trust. And I can't tell you how often I see people who have great trusts in place, but haven't utilized them completely because they haven't actually funded those trusts during their lifetime. And so when they die, assets that they have not put into the trust that don't have named beneficiaries are going to have to go through probate. And we've just kind of lost one of the great benefits of having a revocable trust in place. The other interesting thing that has happened in 2023 with respect to particularly revocable trusts and estates in total here in Massachusetts is that we increased the estate tax limit from $1 million to $2 million. And that has really helped a lot of estates to avoid or at least reduce any kind of an estate tax exposure. We're going to talk a little bit more about that in a month or two in terms of a seminar on how the estate tax change is affecting things. But a revocable trust, if you do have an estate that's more than $2 million and have a spouse, can be a great way to help to avoid estate tax liability upon the death of particularly the second of the married couple. Another thing to remember about revocable trusts is they're amendable. So if there have been changes in your life and you have a trust in place and it's a revocable trust, we can amend that trust. We can make changes to that trust to make sure it's up to date, that it's reflecting your current wishes, and that the people that you've named to be the successor trustees to you are the people you still want to have in that position. So taking a look at your revocable trust, if you have one, making sure that the people you've named to manage things are the ones you want in those positions, and that the distribution of your assets, particularly after your death, are properly reflected in the trust, and that you've funded that trust completely. Put all the assets that you can into the trust so that nothing is going to be kind of subject to the probate process when you die. Now, irrevocable trusts are very different. I like to think of an irrevocable trust like a steel box. The purpose of creating this type of trust is to protect whatever it is we've put in it. Remember, with the revocable trust, you don't have that protection because you're the one who controls it. You're the one who benefits from it. So it's a fancy way of holding your assets while you're alive, but it doesn't provide protection. An irrevocable trust does provide protection. So let's say we take $100,000 of cash and we put it into an irrevocable trust. The intent of it is to make sure that that value, that cash value, is going to pass on to your beneficiaries in the future. Let's say it's your children, or you have siblings that you want to provide for. We put it into this steel box so that, let's say you need something like long-term care in the future. You become ill, or as you age, your needs become such that you have to have additional care. Assets that are in this type of a trust are protected from the cost of things like your long-term care in the future. Now, there are rules around it. So we have to put these types of trusts in place at least 5 years before you would ever, let's say, need something like long-term care and want the state under the Mass Health Program to pay for that care. But we can create the trust in such a way that your beneficiaries will get whatever's in that trust upon your death, and it will be protected from your expenses, your needs in the future. But there are big downsides that you need to know about with respect to irrevocable trusts. There is the loss of control over whatever is put into that trust. So for instance, that $100,000, it's no longer yours to decide what happens to it. And you cannot benefit from that trust with respect to getting the principal value of the trust out again in the future. So you're giving up a lot of control, all control in most cases, and you cannot benefit from the principal value. We can have you benefit from the income value of that trust. So if the money gets invested and creates income, you can get that, but you can't get the principal value back again. Now, in most instances, an irrevocable trust cannot be amended, so it can't be changed. Because if it could, then it would break that protection. But in some irrevocable trusts, we are able to maintain an ability to change certain things. Like maybe we can give you the ability to change the trustees We also sometimes can give you the ability to be able to change how things are going to be distributed after you die. So let's say originally you named your 3 children to be the beneficiaries, and you had a falling out with one of them and no longer want to provide for them. Or their circumstances have changed in such a way that you don't want to provide directly for them, or you don't feel the need to make them a beneficiary of the trust. There can be ways that we can look to change that, but what we can't change is we can never give that asset back to you in any way, because then we have absolutely destroyed the purpose of the irrevocable trust. And so irrevocable trusts become a little bit more difficult to change their purpose and to change who ends up benefiting from it. But if you've had a change in your circumstances, there may be ways to be able to tweak those irrevocable trusts to meet your desires a little bit more. You have to take a look at the trust and see whether that's built into it or not. So that's a little bit of things for you to think about. 2024 beginning, taking a look at your estate plan, looking at your own life, deciding what's important to you and who's important to you, and making sure that that estate plan reflects all of the things that might be changing in your life. Remember, it's a living, breathing thing. It doesn't just get done and be done. It's something you really should take a look at and make sure that it's still reflecting your wishes as time goes on.
Thank you, Kathleen. There's currently no questions in the chat box, but I did want to point out if you want a little bit more information or to read up a little bit more on essential estate planning and figuring out if a trust is right for you, I put in the chat box our website where you can go and download an ebook on, we have an ebook on both topics, on essential estate planning and trusts. We, along with some other topics that might be of interest to you. So feel free to browse around our website. We also have our social media with tons of videos on YouTube. We're always posting on Facebook, Instagram, and LinkedIn. And if you do want to make an appointment to follow up, if you have an estate plan and you think you need to review it with your attorney, just give us a call for an appointment. And we have our client care program, which some of you actually might be members of, which if you are getting an essential or enhanced estate plan, you get a free year to try it out. And there's 2 levels of membership. And if you want more information on that, just shoot me an email and I'll get you the information. But I believe we do have that on our website as well. Is there any estate documents for people with minor children?
Absolutely. So there's 2 ways to be able to provide for minor children. One is in the will. So if you don't want to go with a revocable trust, we can do a will. We can make sure that minor children are taken care of in a couple of ways. One is to identify a guardian who would take care of the minor children should something happen to you and their other parent. And we also can provide language in a will that would hold any benefit that that minor child might be getting in an ongoing trust until whatever age or ages you think are appropriate for that child to get the money themselves directly. So the trustee would manage the money and use it for the minor child until you decided it was appropriate to give it over to the minor child. Now, the difference between doing it between a will and having a freestanding trust like a revocable trust is the court's involvement. With a will, when we include that trust-like language in the will, the court will have ongoing oversight into how things are being managed. When we do a freestanding trust instead, and that can include all that same language about how long you want money to be held for the child, how you want it to be spent in some cases, or if you want to leave that to a trustee's discretion, that is just done privately with the trustee and with the beneficiaries and yourself as the one who creates the trust. So absolutely, we want to provide for those minor children, whether it be through a will or whether it be through a revocable or freestanding trust, to make sure that we know who would take care of the minor children until they got to the age of 18 and who would manage monies for them to whatever age you decide is appropriate that someone be managing that.
Thank you. Do power of attorneys need to be renewed if you don't really want any changes?
So that's an interesting question. The reason I'm smiling about it is because I'll tell you, it's become a bigger issue in our world as we've seen powers of attorney being utilized. Financial institutions don't like older powers of attorney, for one thing. Even though they're not supposed to go out of date, they get anxious about something that may be older. They want to question, is this still in place? And is this really still the person who's being named? The other thing about powers of attorney is that over time, more authority has gone into them. For instance, we didn't even have a digital world back in the early 2000s, and talking about giving someone control over your digital assets was something we never even had thought about. So as time goes on, we add oftentimes more authority to a power of attorney in response to what's happening in the world. So I guess the short answer to that is certainly if your power of attorney is more than 7 to 10 years old, I would absolutely speak to someone about, should I get this updated? If your power of attorney, if you want to change who's been named as your attorney, in fact, then absolutely you want to get that updated. And if you haven't got successor people named, I can't tell you how many times people will have a great power of attorney in place, and let's say they've named their spouse, but unfortunately their spouse has predeceased them, and now we don't have somebody, the surviving spouse no longer has competency, and we don't have a successor named, and now we have to go to the courts and have a conservator appointed. So if it's been more than 7 to 10 years, if there are changes in your own life that you feel that need to be reflected in that document somehow, particularly around who you have named in those important positions, then it's really time to think about updating that power of attorney.
Right. And what happens to a trust when the originators pass away? Does it roll over to the beneficiaries?
So in the properly put together trust, you're going to name a successor trustee. And oftentimes the role of that successor trustee is to kind of wrap things up, to say, okay, the creators of the trust have now passed away. This is how they want things to be handled. This is who they want to benefit from their estate. But that successor trustee oftentimes has some things they have to take care of. Taxes, remember, taxes always get paid. They have to oftentimes identify assets and be able to liquidate, let's say, assets, get bank accounts and bring them in, possibly manage retirement plans if there weren't named beneficiaries. They may have to claim life insurance policies. They may have to sell real estate or somehow dispose of personal property. These are all the things that the successor trustee will have to manage after your death. But then the goal would be, once they've taken care of all those things, made sure the taxes are paid, made sure that all of the assets are gathered and properly liquidated, then they'll make the distributions based on how you've outlined it in the trust, and the trust would end. Some trusts don't end. So if you have a trust that's created for someone who has a special need, or the individual who asked about a minor child, that child, let's say, is under the age of 25, and the trust has said, no, it should be held until they're 25 or 30. Then the trust would go on until those, key points are met, those milestones.
And we have a manual to help the successor trustees if they are ever called to duty. We have a manual to help them walk through, and we're also here for them if they need to call us too.
Thank you, Carol. Because trust, we like to say that the benefit of trust is it avoids probate, and it does, and avoids the courts and all the involvement there. but there is still work that needs to be done by a successor trustee. And so there's always administrative work on behalf of the trust that has to be taken care of.
Thank you, Kathleen, for sharing all that information with us, and we look forward to speaking with you all at some point in the near future.